Divine Justice Ministry with lawyer, professor, and minister, the Reverend Tony Suarez, as your host. The crossroads between law, the Constitution, and religion, where the First Amendment is always the first topic of discussion. Well, good morning, Steve.
Good morning.
This is Reverend Tony Suarez with you, your host of Divine Justice Ministry, a podcast dedicated to try to teach us the crossroads between the law and your faith, and that where it intersects the separation of church and state, a discussion of the First Amendment and the rights thereof. And with me, Steve, I'll see now my co-host on Equal Justice, Divine Justice, and Raw Talk, 3 programs dedicated to different aspects of social society where we try to bring information to you. And today we're going to be talking about your right to exercise your religious freedom, which is the subject matter of almost every show, right? But how far can the government go or employers go in accommodating your religious rights? Because sometimes your religious rights may conflict with the employer's boss. And in many cases, Hobby Lobby, other things like that, we'll probably get into those discussions. But we have a particular case that brought to my attention, and I want to bring a person with us to join us, a friend who's been with us in other shows, the attorney, Marie Masson. Marie, welcome.
Thank you. Thanks for having me. Good morning.
And Marie, thank you. Marie is a labor lawyer. Let me run her banner. And so we can keep while she's talking, we'll be able to show, if people can get her information and look her up. If she wants to give a telephone number, she can give a telephone number if they want to contact her. But because she's a labor lawyer, it occurred to me that'd be a good person to discuss some of the questions that came up in some of our research as I prepare for this show and other topics. And what struck me was, and by the way, so you know that where I get my information, I get it from all over the place. So, I'm going to show you one example of the stuff. Well, I lost my, there it is right here. Add this to the stage. Here you go. That's the Bar Journal. All lawyers get a copy of this magazine every month. And it shows us different articles. There's articles of very specific written for lawyers. So we can't discuss it the way the Bar Journal does it, but it brings us to light things that come out in law. And so that's one of the sources that I always use to get information for what is appropriate. Another one is this one, as a Liberty magazine that's put together by the Seventh-day Adventists. And the Seventh-day Adventists have a very active division that has to do with freedom, liberty. As you can see, this is a picture of Donald Trump with Paula White as they invoked God, Jesus, to invoke the president. So the question they have there in this magazine, every month that they publish, is protection or promotion. And that is basically part of the problem that we have with the First Amendment and all litigation that has to do with freedom of religion, of religious freedom, right? So that's what we're going to be discussing, and so let's talk about what this means in general. I'll set the stage, Marie. Okay, we know we have discussed this many times on this program that the First Amendment, the First Amendment of the United States Constitution guarantees that the government may not impose a religious view or establish a religion, is a terminology, nor may it prohibit you from the free exercise of your religion. So what that does is prevents the government from doing it. Then you have, of course, the private businesses also have their practices and procedures which may affect your right to exercise your religion, and that come in the Title VII, which has to do with Religious Discrimination Act, which it requires the private entities from being prejudiced against individuals or behaving in such a manner that will prejudice the religious right of someone who's practicing. So in the case that brought my attention that was reported in the Bar Journal had to do with a gentleman who was working for the post office and did not want to work on Sundays because he believed that uh, Sunday is a day of rest and sacred, and commonly called a Sabbath. Right now, and eventually he started working that way, and then that location where he was working changed their orders, and they started delivering packages on Sunday. They gave him an obligation then to work on Sunday. He refused, and he says, "I don't want to work on Sunday. You could have everybody else work on Sunday." So then the postal service said, "Well, we can't do that. We cannot accommodate you." So he quit, and then once he quit, he sued. He sued because they violated, because that failure to accommodate him violated his rights under the statute to a reasonable accommodation of his um, of his faith. So with that set stage, you can see how difficult it is. If I let's say I have a restaurant and I'm Sunday is my most important day, and I got an employee who tells me I cannot work on Sundays. Well, that's going to be a big that could put a big strain on me as the employer. And then I have a class. If I fire the person, can he sue me? What rights do I have as the owner of the business? And you know, like if you really need the job and you don't want to lose your job, but you're very deep in faith, what do? Do you quit? So these are the real deep questions that are faced in this and many others. Many other situations. I guess we can go into those as we get into the discussion, Marie. But I like your explanation because you practice in this area. Tell us what you have seen and what your interpretation.
Yes. Well, thanks for having me. And I want to clarify because I see my banner as a labor attorney and I'm an employment attorney. Labor and employment is an entire area of law. Labor deals more with unions, which is not an area of my practice, but I do deal with employment issues such as defending people's First Amendment rights and civil rights, correct? And so this particular case, Gerald Groff versus DeJoy, this is a postal worker for the U.S. Postal Service who sued the postmaster, Louis DeJoy, because of what you just explained. All of a sudden, the U.S. Post Office wants to accommodate the increase in deliveries of Amazon packages. And so they started adding, if we remember a couple years ago, Sundays as delivery days. And when he refused to do that because of his religious reasons, that became an issue that went all the way up to the U.S. Supreme Court. Right. Now, just to break it down very simply for people who are familiar or unfamiliar with the U.S. federal statutes, there's a law, it's called Title VII, that says that employers have to accommodate your religious practices as an employee, unless doing that would cause the employer, in this case, the U.S. Post Office, what's called undue hardship. Okay. But as in many areas of the law, decisions hinge on how you define certain terms. So how do you define what's an undue hardship? Is it a set amount of money? Is it a particular rule or a particular damage that's caused to the employer? So
yeah, let me stop you there right there a second. So let me make the people repeat this is important. While the statute says they have to give you reasonable accommodation, it also said that it could not, that reasonable accommodation cannot be undue hardship on the employer, correct?
Correct.
So it's a balancing act. And so now the court has to balance what is reasonable and what is undue hardship, correct?
Correct.
I have a question.
This decision hinged on the undue hardship part of that equation. Yes, you have to provide reasonable accommodations, which means you can't ask for something that's going to be a complete advantage to you and put other employees in peril or a complete disadvantage compared to you. It has to be reasonable in that sense. And so for almost 50 years, all of the U.S. courts had been using the same rule that was very employer friendly. There was an old case in 1977 that said if accommodating an employee's religious accommodation request cost the employer anything more than basically nothing, or in legal terms, what's called de minimis, or something very minimal. If it cost anything over minimal, that counted as undue hardship. So you could see that employers, including the government, could get away with anything, saying, no, if it's going to cost me to pay a more senior employee to work on a Sunday overtime because they make more an hour, that's more than the minimus. That is unreasonable, and that is an undue hardship for me as an employer. That was the old rule.
Let's concentrate on that. So make sure, Steve, you got what she said. Did you get that?
Yes, I do. But my question to you is, what happens with the right of work states? Okay, where here in Florida, you have the right to work as long as your employer employs you. If he decides for any reason whatsoever to get rid of you, for whatever reason, they can do that, and you cannot do anything about it.
Okay.
So does that goes under there also, or is that treated separately?
No, that is a completely separate issue, Steve. And let me clarify for our listeners, Florida is not a right to work state, okay? We do not have any statute at the state level that guarantees work for anybody in Florida.
Exactly.
Unless you enter into a contract of employment with your employer where both parties sign and outline the terms of your job, this is a state that's called a at-will employment state. Okay, and the majority of states in the US are at will, which means, in simple terms, that you can quit at any time for any reason, and your employer can fire you at any time for any reason, and you don't have a right to sue them for firing you unless the firing is wrongful because it's discriminatory, meaning that it was discharge or termination based on any of the protected categories that are guaranteed under Title VII, which is your national origin, your race, your gender, your status as pregnant, etc., and your religion. There's a number of protected categories. But in Florida, basically, it's at will. A lot of people get confused with that and come to the office saying, hey, I think I was wrongfully terminated, and I have to set them straight and say, you don't have a right to work in Florida. It's at will. Let's see what reasoning they gave you for firing you. If it's insubordination, for example, if it's absenteeism, and there's a policy that after a certain number of absences, you're out, it's completely legal and you don't really have a basis to sue. But when we're discussing this case here on religious accommodation, you don't have a right to be employed regardless of your religion. You have a right to keep your employment so long as you're not discriminated against based on your religion. If you feel like you were demoted or you're denied certain accommodations, yes, then you have a right to sue, regardless of whether the state is at will or not. Does that clarify the question?
Yes, ma'am. Thank you.
All right. Great. I needed to make that distinction because it's a very common question we get in practice. So I was saying before, the old rule back from the 1970s was very employer friendly. And as we know, we have a very controversial U.S. Supreme Court, okay? And as of 2023, it was very rare that the justices would be unanimous, or meaning all 9 of them agreeing on a decision. And in this particular case, Ralph versus Sejoy, they were unanimous. It's one of the few where they completely agreed that the rule that we had before that required that de minimis showing by the employer was wrong. So they agreed that the old rule needed to be done with. They said undue hardship should mean something much more serious, a substantial burden on the business, not just any tiny inconvenience. So employers now have to clear a much higher bar before they can refuse to accommodate somebody's religious request or their religion. The court also said things like co-workers rumbling because they dislike accommodating religion doesn't count as real hardship, okay? Somebody's request might, ruffle feathers and people might, look down upon you because of your religious belief. They could bring it up to a supervisor. Guess what? The court said that's not enough for an employer to decide. We're not accommodating. You're just creating, a discomfort in the workplace. So that is actually not enough. You have to prove as a party, as a defendant, that your business itself is actually hurt by accommodating this particular employee's religion. So in legal terms, the result is, the case was sent back down to the lower courts. They had to reconsider under the new standard that the court provided, which was more employee friendly, whether they could accommodate it, considering what was the actual damage to the employer, to the post office. Right. So now employers have to work a lot harder, needless to say, before saying, sorry, can't accommodate.
Yeah, so that's exactly what the point is, that the decision on Groff tells us that now the accommodation, what is reasonable, must be undue burden, and you have to prove the undue burden, not just anything that you claim. Oh, it's going to increase my payroll by a penny or $1 or make it more difficult. It has to be more than what we call de minimis, right? It has to be more. So you have to prove that undue burden. It's going to be those lawyers that represent businesses are going to have to show why this is a real hardship on that person. I think that is what the Supreme Court has said, and now give us guidance for people like Marie, who are representing employees or employers, to give them a standard for when they have to go to court. What evidence will they need to collect to make this accommodation of the religious right? So is that a good summary, Marie?
I believe so, yes.
Okay. So let me change the topic a little bit, because now we go from that one particular case and to discuss something we had a very famous case in Florida of a woman who's Muslim who wanted to wear her veil, because that's her belief of her religious belief, to wear a veil and not be exposed. But she was applying for a driver's license. In Florida, you have to have your photo of a driver's license, and she refused to take her veil off for the photo. This went up to the Florida Supreme Court, did not go up to the United States Supreme Court. But in that particular case, the court ruled that the state's interest in having a photo ID with a face overrode the religious right of this person to hide her face. And the court went so far, Marie, in that particular case, to actually go into the religious beliefs of the Muslims, because there are some Muslims that believe you have to cover, others do not believe that they have to cover. And so the court made a determination which was a valid belief, as opposed to what the court felt is the majority a determination of what's valid, and then gave the government the exigent circumstances or extreme circumstances. Their interest is above the individual rights. So let's discuss how far can the government go, or even states go, in impeding the individual rights. I know we had the cases of Hobby Lobby, which we did not allow. Well, Hobby Lobby decided they were not going to provide abortion pills and abortion services within their medical plan for their employees, because they're strict Christians and they believe that providing that kind of service through their employment violated their corporate rights to control the religious. And so there was a lawsuit there, and Hobby Lobby won. Hobby Lobby had the opportunity to say their corporate rights to impose a religious view upon their other employees was a protected civil right. So I wonder if you could give us a general breakdown on this area of law.
Sure. You want me to start with the one with the veil?
Yeah, go ahead.
So, like we said earlier in the show, courts are tasked with balancing the interest of the parties. Sometimes the parties are the state, or the federal government. Sometimes it's private industry. So in the case of the driver's license and the Muslim plaintiff's refusal to take it off, or the driver's license, the interest that they're balancing is the public safety versus an individual's right to exercise their religious freedom, right? And in that case, it was clearly decided that the public interest in having an entire swath of the population uncover their faces is not outweighed by the public safety. Correct. So we need to have safety for the entire population. So it would be, in their view, unfair to have one particular sector of the population be able to subvert that, or take advantage of that to protect their religious freedom. The analysis that they did, that you pointed out to, it focused on the optional nature of wearing the veil. Some Muslims don't cover their faces. Why should it be any more burdensome for you to cover or uncover it just for the purpose of the picture, right? So in balancing those interests, the state safety reasoning and interest for the benefit of the entire society won over the religious rights of what they considered a very minority group of the population. And then when we're balancing the rights of private industry, considering the Hobby Lobby case, again, they're balancing what options do we have versus what rights and what measure of exercising your rights is proper and reasonable. And in that case, if I remember correctly, the employees had an option not to choose the health insurance plan offered by the employer, right? By Hobby Lobby. You're not happy with the coverage we are providing you because it doesn't cover contraceptives. You always have, at that point, you have the marketplace, or you have the option of not accepting our health insurance and getting it on your own. We're not depriving you of the right to get contraceptives. We're just not facilitating it through us. The argument was, well, you're discriminating against employees who don't have the same religious beliefs as you do and work for you. And, you're benefiting employees that do align with your religious perspective as a corporate entity. But ultimately, because it was private industry and there were options, the court ruled in favor of Hobby Lobby. That's interesting. I mean, the concept of a corporation having religious affiliations or religious beliefs is kind of strange. That's usually left for the individuals. But, this is the beauty of our justice system. You get to argue before courts and get to argue before different panels of appellate judges, and anything can happen.
Yeah, I didn't see that the discussion of whether a corporation can have religious views was actually a point, because it wasn't discussed in any tribunal. So
no, I'm just pointing out that it's an interesting concept that was not really fleshed out, but really it deserves attention because, in my view, the corporation really is the board that's behind it and gets to make the decisions, right? So it boils down to what that core group of the corporation makes official as far as the position of the corporation. But yeah, they did not go into that in detail in the opinion.
Okay, Steve. Now that we've gone through this discussion, tell me what you think. Has it all been cleared up in your brain?
Oh, friend, I believe that we all have rights, and if you own a business and you have beliefs, religious beliefs, and you want to implement those, and that includes, how you are going to provide health care to your employees. I think you are in all your rights to do what you want to do as an employer. Like Marie was saying, you have the option of going to the marketplace by yourself. The group insurance is a lot more convenient because your premium will be a lot less, but that's a choice that you would have to make, So I see both sides, and I don't have a problem with it. It's a matter of.
Okay, let me give you a problem so you could.
Okay, give me a problem.
Okay, let's say, Steve, you own a business downtown, all right? And you're in an older business, and now you you apply for a permit to fix the front of your building, and now the government comes, oh, you now have to put a ramp because we changed the laws to give reasonable accommodations of people who have disabilities, and now, Steve, you have to put a ramp. And so you investigate, and it's cost you $10,000. So you say, okay, you go back to the government and say, I'm willing to put the ramp. Are you going to give me the $10,000? Do you think the government is going to give you $10,000 to fix the building so you can accommodate the disability of someone who may or may not come into your business? What do you think about it? Now you have the problem is yours. What do you think?
Well, if it's gonna affect my business, I look at it as an investment. Okay, and if you have a business, you have to invest in your business. Okay,
Right.
so if you want to have, my apologies.
Bless you.
Thank you. If you want to have people that come into your business that have certain difficulties or necessities, and that is the law, then it is what it is.
The question is, should it be the law?
Well, I think that,
Is it unfair to the owner of the building?
excuse me?
Is it unfair to the owner of the building?
It could be unfair or considered unfair, but the law is the law, and if you want to continue with your business and you have to accommodate, well, you accommodate. If that's your choice to continue with your business. Business requires investment, it requires money, and if you want to expand, then that's what you have to do. That's what the law says. Then if you don't do it, then you are infringing on those people that have problems, and I don't think that's fair. So, if it was me and I own the building and it's going to cost me $10,000, I'm going to cry about the $10,000, but I'm going to have to do it, because number one is the law. Number two, I don't want to infringe on other people's rights to coming into my business to grab my service and utilize my services in the business, and I don't want to limit the door, coming in or coming out. So if that's what I have to do, and that is what the law requires because of the special needs, guess what?
All right.
You got to do what you got to do.
You got to do what you got to do. It's called public policy. It becomes part of the public policy, and so the weight there is whether the government has a right to impose that kind of restriction or that kind of obligation. And clearly they do have such a right. And the landlord the owner just has to comply. I mean, that's basically where it is at the moment. But I wanted to bring up the problem so you can see how it could be the burden is not shared all the time, all along. And the burden is going to be placed by public policy, by politicians who select public policy, how the burden is to be shared. So they create a law like the Title VII, the anti-discrimination law, but someone going to have to do something. And the golf case that we just discussed puts the burden on the employers now to have to come up with a better standard than just say it is inconvenient for us. You have to prove the harshness upon them. And so there's going to be standards, and you have religious rights. You have the First Amendment, but it's going to be balanced against other rights. And what we're trying to do, of course, here with this show is bring to light that balance, how that is, how it works, what's the thinking, right? Including the clip they did on how judges make decisions and whether textualists or whether or not they're progressive judges and so forth. Marie, I want to thank you for joining me for this clip. Marie, if you want to give us a number, anybody wants to contact you, they need to please give it to me now.
Sure. MassonLawFirm.com. It's my last name. Lawfirm.com is my website. We're here in Central Florida, serving Orlando and the suburban areas. I'm in Clermont too, so Lake County, Citrus County, Orange, Osceola, Polk, and all of the surrounding areas. We're happy to help you. 352-777-9222 is our phone number. 352-777-9222. You can call us for a consultation and we'll be happy to let you know if you have a case or not. I wanted to also address something that Steve was saying when he was giving his perspective in the hypothetical, if he was a business owner. I do get both employees who have been aggrieved at work and employers who have been sued all of a sudden, right? If you're one of those business owners that listens to this show, be aware that you're always, unfortunately, not the losing end, but always exposed to losing a lot of money because you have to defend yourself against people who sometimes come to sue you frivolously, but sometimes come with, valid claims. And so you always have to look at that sort of situation where you feel the law is imposing an extra cost on your business as compliance and as insurance. Look at it from that perspective. It's better to comply with the law than have to defend yourself and spend money anyway, and then being ordered to comply with the law at the end of the day. So always keep that perspective that in this country, being in the legal system costs a lot of money. So just comply. It's the best approach, the best practice when you're a business owner, and get a legal consultation. Sometimes you might feel like you're on the right. So spend the money on a good attorney, get a consultation, get all of your questions answered, and that can probably save you a lot of money down the line.
You will, because in fact, I know that there were cases where I had clients who were restaurant owners, and there are lots of ADA, American Disabilities Act requirements for stools and sizes and that. And if you don't comply, you're in violation. And there was someone going around all of the restaurants at one time citing restaurant owners for violations of the ADA. And they were getting sued, and there's really difficult. You either comply or you're not in compliance, and then you have to pay. So it gets expensive. Marie, thank you so much for joining us today. Those of you who are interested, know that every Wednesday we'll have the show Divine Justice, the intersection between faith and the law. On Tuesdays is Raw Talk, just pure politics. And on Thursdays, we have the Bar Association Moot Court and a conference on the question of Puerto Rico, its constitutionality, and its status. So those of you interested in we call that show Equal Justice. So thanks, everybody. Thank you very much. We'll see you next week. God bless. Bye-bye.
Thank you.
Take care.